Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, excuse me. Good evening. Thank you for being here. You may all be seated. I'll have counsel for the record identify themselves. Yes.
Good evening, Your Honor. My name is Hope Rawlson, and I'll be addressing the Fourth Amendment issue on behalf of the petitioner today.
Thank you, Ms. Rawlson.
Good evening, Your Honors. My name is Bock, and I'll be addressing the Eighth Amendment issue for William DeNolf, the petitioner in this case.
Excellent. Thank you.
Good evening, Your Honors. My name is Paulina Hruskoci. I will be arguing the Fourth Amendment issue on behalf of the Respondent.
Thank you, Ms. Hruskoci.
Good evening, Your Honors. My name is Olivia, and I will be arguing the Eighth Amendment issue on behalf of the Respondent.
Excellent, and thank you. You may be seated. And before we begin, I just want to congratulate all parties for your success thus far, and congratulate for being here. Excellent. Welcome. So, Petitioner, if you're ready.
Yes, Your Honor. And before I begin, I request 2 minutes for rebuttal.
Granted.
Thank you. Can everyone hear me all right with the microphone? Thank you.
Yes.
Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Hope Rawlson, and I, alongside my co-counsel Isaac Bock, represent Mr. William DeNolf, Jr. The Fourth Amendment guarantees citizens the right to be secure in their homes. Today we ask this Court to uphold that right and find that law enforcement may not use rare, stealth technology to peer into the windows of a home. To this ruling we present 2 points. First, that William has a subjective expectation of privacy inside his family's motorhome. Second, that William has an objective expectation of privacy.
Counsel, isn't it always true that homeowners have an expectation of privacy in their own homes?
Not necessarily, Your Honor. In Katz v. United States, Justice Harlan noted that an individual may not have an expectation within their home.
Why is that?
If an individual knowingly exposes those actions to the public, Your Honor.
Such as?
Such as, the Court didn't give a specific example.
Can you?
Sure, Your Honor. If an individual is living in an apartment in the middle of the city on the ground level, and then has maybe completely glass windows, and an individual happens to walk by, that
What
may...
if the curtains are closed?
Then no, Your Honor.
And the situation here?
The situation here is different, as this Court articulated in Kylo v. United States, Your Honor, because it was only through advanced technology that law enforcement would be able to see inside the RV.
Were the windows open?
Yes, Your Honor.
Were the curtains open?
Yes.
So was there an expectation of privacy?
Yes, Your Honor.
Under Katz?
Under Kylo and under Katz.
Why?
Because in Kylo the Court found, similarly, that while heat was technically exposed to the public because it was on the outside of the home, that heat was only viewable through advanced technology. In this case, the facts are similar.
But here we're talking about visible, not heat. Is there a difference?
No, Your Honor, not under this Court's reasoning in Kylo, because the reasoning in that case was because it was only through advanced technology.
Are you asking us to extend that reasoning?
Yes, Your Honor, but it's not really an extension, but more so an application of the precedent that this Court already decided.
An application to a new scenario is an extension, yes?
Yes, Your Honor.
So you are asking for an extension?
Yes, Your Honor.
Okay, continue.
On Appendix 2, Column 4 of the record, it explains that this drone is equipped with video streaming quality that is 4 times that of the next level down, the prosumer model.
But wouldn't that technology that was on this drone be pretty similar to what's on a smartphone today? Is it really that unusual a technology?
Yes, Your Honor. The difference is that a smartphone is only equipped with magnification technology. It's not equipped with optical zoom technology. The difference is that the reason why you zoom in with your smartphone, that it's blurry if you zoom in all the way. The difference is that with this drone, if it's zoomed in all the way, it doesn't necessarily produce the same blurry video quality.
What happens if somebody has superhuman vision? Superman, for example, doesn't need any technology, can just see into people's houses. Is that what happens under your theory of this case?
That would be unconstitutional if law enforcement were to use Superman because it's not in general public use. The standard that this...
It's just their eyeballs.
Correct, Your Honor. So in that hypothetical situation, it would be different, but obviously an individual doesn't have the visual capabilities of in that manner. And so the only equivalent that this court can look to is the zoom and video quality of drones, which virtually do the same thing.
Right, but my understanding of your theory of the case is that applying that to some superhuman capability that somebody has through some quirk of nature and is born that way, that would also be unreasonable. Is that what you're saying?
Yes, Your Honor. If law enforcement were to utilize some advanced superhuman capabilities of Superman, then that would most likely be unconstitutional.
What if they didn't know? It was just an officer who happened to have that capability and could look into other people's houses from long distances and see things and didn't know that everybody couldn't do that. Is that also unreasonable?
No, Your Honor. But underneath this court's precedent in Kylo, the standard that this court is held to is what's in general public use. This drone is not in general public use for two reasons. First, because it's categorically different than every other drone on the market. We are not asking this court to find that a generic drone is unconstitutional, but only that the Stealth Eagle 2020 specifically.
So, but isn't it really only different in that it can go a little faster, it can go a little quieter, and it can fly a little bit longer and maybe a little bit higher than other drones, but largely it functions just the same as other drones, right?
No, Your Honor. There's a reason that this drone costs nearly $24,000 more than every other drone on the market. Its video quality is not only 4 times that of the next, but its sound is 1,000 times quieter than the next level down.
But it is available on the market. I can go and buy it if I want to, if I have the money to do it. You can go and buy it if you have the money to do it. Anyone can buy it if they have the money to do it. So why is this not in general public use?
This court should turn to Kylo to answer that exact question. In Kylo, the court made a distinction between something being available and being generally used by the public. In that case, Justice Stevens noted that thermal imager devices were quote-unquote readily available to the public. But the majority found that because thermal imaging devices were not in general public use, then they were not constitutional for law enforcement to use without a warrant.
But if we also turn to Florida v. Riley, is a helicopter in general public use?
Yes, that's exactly what this court found in that case. They used the term routine use because Kylo had not yet been decided. But in Kylo, in footnote 5 of that decision, Justice Scalia noted that he based his general public use test on the test used in Riley, the routine use test.
I don't know what a helicopter costs, but I could go and buy one. I imagine $25,000 won't get me very much of a helicopter. So why is this such a different scenario?
For 2 reasons, Your Honor. First, while an individual may be able to purchase a helicopter for as much as this drone costs, that's not what the average American is doing. They're purchasing a helicopter ticket or a plane ticket, which only costs a few $100s. But secondly, the Stealth Eagle 2020 used in this case is not in general public use, because the technology equipped on this drone is categorically different. This court can also turn to page 3, paragraph 3 of the record, which explains that the Stealth Eagle drone is known as the quietest drone ever made. An individual knows what a helicopter sounds like. They know what a plane sounds like. They may even know what a regular drone sounds like. But an individual could be followed by this drone for days, weeks, even months, and have no way of knowing that they were being watched.
So is it important that the person knows that they're being watched? Is that part of your test?
It's not part of the test, Your Honor.
But you just spent several minutes talking about it. Why does it matter?
Because it provides law enforcement with an advantage that is not in general public use.
Is that precedent? Have we said that?
General public use, yes, Your Honor.
Yes, but the ability of a suspect to know that he or she is being watched?
No, Your Honor. What this court has held in Lopez versus United States, as cited in Katz, is that the usefulness of technology is dependent upon the lack of notice to the suspect. So that paired with the precedent in Kylo, that of the general public use test, it's reasonable for this court to conclude that the stealthfulness of technology gives law enforcement an advantage. And if that advantage is not in general public use, then it fails the Kylo test and also violates an individual's reasonable expectation of privacy.
Counselor, I see that you have 1 minute left. Can you please tell us how your position relates to standing precedent? You already said that you're asking for an extension. Are you asking, does your position require us to overrule any of our precedent?
Not at all, Your Honor. We are only asking this court to rule in line with how it did in California versus Cerello, Florida versus Riley, and Kylo versus United States.
And extend those cases, correct?
Yes, extend those to the use of optical technology and stealth technology, in this case in the form of the Stealth Eagle 2020 specifically. We are not asking this court to categorically prohibit the use of this drone, but rather to simply require that law enforcement must first obtain a warrant. In this case, rather than obtain a warrant, law enforcement obtained a $25,000 drone and used it to peer into a child's window. Because that violates the Fourth Amendment's guarantee that citizens be secure in their homes, we ask this court to overturn. Thank you.
Thank you, counsel. Counsel for it? Okay.
Hold for just a minute, please.
Sure.
I am ready.
I'm not.
Okay.
Thank you, counsel. You may proceed.
Good afternoon, Mr. Chief Justice, and may it please the court. My name is Isaac Bock, and I represent William DeNolf on the Eighth Amendment violation. Graham versus Florida controls this case. There, this court confirmed what every parent knows. A child is not the same as an adult. So a sentence that denies a child convicted of a non-homicide offense a meaningful opportunity for release is disproportionate and unconstitutional. William DeNolf's sentence violates Graham and the Eighth Amendment for two reasons. First, William's sentence of half a century in prison before parole denies him a meaningful opportunity for release because it puts his first chance for release more than a decade past when he's expected to die. And second, the trial court's finding that William is incorrigible as a 15-year-old child likewise denies him a reasonable opportunity for release because it unconstitutionally brands him as incapable of reform and prejudices a future parole board against him.
Are you saying that the incorrigibility finding was factually wrong, or are you saying there's a legal principle that would have precluded him being found to be incorrigible?
A legal principle, Your Honor. And the legal principle is found in this court's essential holding in Graham, where it held that for juveniles convicted of a non-homicide crime, findings of incorrigibility are inconsistent with their youth. Not necessarily because they're factually incorrect, but rather because trial judges cannot know when a child is a child whether or not they are irretrievably corrupt. In striking down Terrence Graham's incorrigibility finding in that case, the court cited studies from the American Psychological Association, which attempted to predict whether or not children will become future homicide offenders.
But Miller and Montgomery call for findings, or that was abrogated in Jones, but there was talk about finding incorrigibility in those cases. So are you saying that it is impossible to find incorrigibility in cases, and so therefore like the life without parole sentences for homicide offenses, that those cases envisioned are also categorically unconstitutional?
Your Honor, the Miller and Montgomery cases are confined to juveniles who commit homicide crimes, and the court was very clear to make that point.
Now, Mr. DeNolf here may not have committed a homicide crime, but that appears to be only because of the timely and lucky intervention of the police in this case. So how is it functionally different from the behavior of those cases?
Your Honor, because in the words of this court in prior holdings, death is different. In Graham, this court found that even the most serious non-homicide crimes, including attempted murder, are different from homicide in their severity and irrevocability, because death ends a life. And because of that, the penological justifications for a hefty sentence and a finding of incorrigibility exist in the context of a homicide, but do not exist in the context of even the most serious non-homicide offenses.
I want to ask you about the meaningful opportunity for release. You talked about how he's going to likely die 10 years before he's eligible for release. How is that knowable?
Your Honor, it's notable because of the lower court's opinion in the Supreme Court of California.
Sorry, I didn't say notable. I don't know if you heard that. Knowable.
Oh, knowable. Yes, Your Honor. I would ask this court to turn to page 6, paragraph 4 of the record, where both sides have stipulated that inmates in the United States live on average 39 years once they're in prison for a life term.
But surely there are many prisoners in custody who are well over 65 years of age, including some who have been in prison since their teens or early 20s.
Yes, Your Honor, that is correct. And this study is an average, and so it is only, a 50% estimation of where his life expectancy will end up. However, based on this estimate, William DeNolf is expected only to live to the age of 54. His sentence, however, means that his first chance of release is at the age of 65, 11 years after he's expected to die.
But that's a guess, as you just stated. So if that's 40% his life expectancy, then 60% he'll live longer than that, which means he'll get out after his sentence is complete.
Your Honor, we want to characterize it as a guess, but rather an average, and it certainly is that. However, on page 6, paragraph 4, based on that average, even the state of Olympus has stipulated that William DeNolf specifically can be expected to die before he's eligible for parole and release.
If we don't adopt that understanding, do you lose?
No, Your Honor, we do not lose because it isn't just the excessiveness of the sentence that denies him a meaningful opportunity for release, but also the incorrigibility finding itself. Because the finding will poison the well and prejudice a future parole board against him.
So if we think that, there's a decent chance he'll live to 65, have a shot at parole, and die out of prison, does that defeat your meaningful opportunity for release argument, even if it doesn't defeat your incorrigibility argument?
No, Your Honor, it doesn't, because this court in Graham was clear. Justice Kennedy did not use the term simply a chance of release, but he said a meaningful and realistic chance. And when the government can stipulate in a case that they do not expect a child to actually live to their chance for release, that is a denial of a meaningful opportunity.
Are courts bound by party stipulations?
In this context, Your Honor, they certainly are bound by those stipulations in the sense that in order to overturn them, they probably have to be found in clear error, according to the lower court's decision in Long Lake Township versus Maxon. However, in the context of just the categorical rule of Graham, I direct this court's attention to the lower court decision in People versus Caballero, where it found that when a sentence for a juvenile convicted of a non-homicide crime, when that sentence exceeds natural life expectancy, it violates the meaningful opportunity test that this court articulated in Graham.
And I think we could all agree that if it was 100 years until he was eligible for parole, there would be no prospect of him ever being released. But 50 years, he could very well live to 65. He could live to 75 or even 85. Is that not a meaningful opportunity for release?
Your Honor, it isn't a meaningful opportunity when, once again, even the government can stipulate that he's not expected to reach that date. But further, it's
Counsel?
also... Yes, Your Honor.
I disagree. Tell me how you win absent that stipulation.
Your Honor, we win absent that stipulation because of the incorrigibility finding in this case, which this court stated in Graham is categorically prohibited for juveniles who commit non-homicide offenses. And the reason for that is because even trained psychologists fail to accurately predict whether or not a child is incorrigible 87% of the time, according to the American Psychological Association.
I want to go back to the meaningful opportunity for release. So if he is released around the age of 65, would you agree he would have really no opportunity for a career, probably no opportunity to have children? Does that impact the meaningful opportunity for release inquiry?
Your Honor, it certainly does in the sense that the parole board, when they're making a determination for release, base their determination on success under supervision outside. And so the fact that he is released at a point where he'd basically be in retirement with no potential for gainful employment would likewise deny him a meaningful opportunity for release.
So for a young offender under the age of 18 who is given a life sentence, what is the constitutionally maximum period of time they can be held without parole eligibility?
Well, Your Honor, we don't believe that drawing a firm line is necessary in this case. If this court chose to do so, it should turn to its holding in Graham that it should look to national consensus through actual sentencing practices across the nation to look to find that line. And according to page 8 of the record, 70% of juveniles who commit the same crime that William DeNolf did receive a sentence that does not exceed 25 years. So if this court were to draw a line, it should do that at 25 years in order to remain consistent with this precedent. Your Honors, William DeNolf does not ask for release or the certainty of release. He simply asks that at some point in his natural life, he be given an opportunity for a second chance. The Eighth Amendment requires that juveniles convicted of non-homicide offenses be given that hope for some years of life outside prison walls. Because his incorrigibility finding and his sentence of half a century in prison denies him that meaningful opportunity for release, we ask this court to reverse.
Thank you, counsel. We'll hear for the respondent.
I proceed, Your Honor.
You may.
Chief Justice, Associate Justices, and may it please the Court. Today, we ask that this Court uphold the decision of the lower court on behalf of the respondent, the State of Olympus. My name is Paulina Hruskoci, and I will be arguing the Fourth Amendment issue. My partner, Olivia Cooper, will be covering the Eighth Amendment issue. Your Honors, no warrant was required by the State of Olympus for two primary reasons. First, the RV is a vehicle. Second, DeNolf Jr. had no reasonable expectation of privacy from drone surveillance. Moving to our first point.
All right, counsel, I have a question right off the top. Why not get a warrant? How difficult is it to get one?
Your Honor, in the case at bar, the record is silent on probable cause. However, no warrant was required because it did occur in a vehicle, and the State of Olympus simply used publicly available technology rather than obtaining a warrant.
You call it an RV that has flat tires and has been stuck in the same place a motor vehicle?
Correct, Your Honor. This is a mobile vehicle because it could be moved at any time. And as this court stipulated in California v. Carney, the automobile exception exists because of the pervasive regulation that vehicles capable of moving on public roads face.
Counselor, what about mobile homes? They're equally movable, or can be.
Your Honor, a mobile home, if it was used primarily for residential reasons, may be an exception to this rule. However, this was a recreational vehicle with 4 flat tires. It could have been moved at any time, although it may be
I have a question. Isn't the vehicle an exception, excuse me, already an exception to the warrant requirement? So this is an exception to the exception?
Correct, Your Honor. However, this California v. Carney case did stipulate that RVs are subject and part of the automobile exception from the warrant requirement.
At all times, under all circumstances.
There was some exceptions made in California v. Carney per footnote 3. They detailed some of the elements that might impact the court's decision, including updated license and registration and ready mobility. According to the record, Comaford had recently applied for a new registration and license. Additionally, although it was on 4 flat tires, it was readily mobile at the turn of the ignition, according to the record. It could have been driven off of the property at any time.
What's the justification or the rationale for the automobile exception?
Your Honor, the justification is because of the pervasive regulation that vehicles face that are capable of traveling on public roads. Because of this, there was an urgency that the State of Olympus had when Comaford applied for a new vehicle registration and insurance. There was an intention to potentially move the vehicle in the future when he completed this registration. Additionally, Your Honors, DeNolf Jr. was a temporary visitor to the recreational vehicle. This court ruled in Minnesota v. Carter that temporary social guests are subject to a lesser expectation of privacy than, say, overnight guests or owners of the home. On page 3, paragraph 1 of the record, DeNolf Jr. states he simply went there to be left alone. This was not his primary residence.
Well, counsel, you mentioned the reasonable expectation of privacy, but you didn't mention whether he had a subjective expectation of privacy. And when I look at this case, I find that troubling because he invited a third party to whom he is not related onto this property. Do you concede that he had a subjective expectation of privacy?
Your Honor, because DeNolf Jr. went there to be left alone, we do stipulate that he may have had a subjective expectation of privacy. However, per the Katz test, society is not willing to recognize that expectation as reasonable. And that moves to our second point, which is that DeNolf Jr. did not have a reasonable expectation of privacy from drone surveillance. This court has ruled in both California v. Serralo and Florida v. Riley that publicly navigable airspace can be used for surveillance. Rather than looking to cases such as Kylo, which refer to not an observation, but a actual technology used to permeate the border of the home, we ask this court to instead look at these cases referring to observation.
Those cases were decided at a time, when technology was much less robust than it is now. When the ability to observe the intimate details of a home from that airspace were not available. So our court could not have predicted a time when that would be different. And I wonder if it's warranted to extend that rule to a situation such as we have here.
Correct, Your Honor. Technology is certainly advancing at a rate that none of us might have expected. And that's why we asked this court to also consider Kylo v. United States, which asked this court to consider whether the technology is in general public use. The Stealth Eagle 2020 is in general public use. It was available for purchase by the public, and according to page 4, paragraph 1 of the record, several people have chosen to purchase it. Wildlife enthusiasts, hunters, paparazzi, all of these people have chosen to purchase this for these purposes. And according to Florida v. Riley, this court ruled that if the officer's actions could be accomplished by a private citizen, it was not a violation of the Fourth Amendment. Although technology is certainly advancing, it's advancing for the public and the state of Olympus at the same rate. And the state of Olympus has a right to utilize such technology available to the public to complete such observations.
Are you suggesting that such a drone is as common as binoculars?
Your Honor, it may not be as common as binoculars. However, we do stipulate that it is in general public use, the test established by this court in Kylo v. United States.
The petitioner argued that the camera that was on this drone was significantly more advanced than, say, what's on an iPhone, for example. Do you agree that this camera is that much more advanced?
Your Honor, the camera is more advanced. However, according to Appendix 2 of the record, the prosumer model is also equipped with the 10 times optical zoom lens that was primarily relied upon by law enforcement with the Stealth Eagle 2020. Additionally, 8% of the United States population possesses similar drones, and 15% have at some point operated one. Drone use is becoming increasingly routine, and the state of Olympus must adjust their tactics in order to keep up with such increasing technology.
Counsel, under your rule, I can imagine a scenario where technology develops to the point where people can just walk down the road with their cell phone and look through people's walls. If that is generally available, under my understanding of the rule that you're advocating, that would not be a Fourth Amendment violation for an officer to do that. Is that true?
Your Honor, this court could choose to make that determination. However, we also ask you to consider the observation aspect of the Stealth Eagle 2020. It was an observation that occurred, rather than technology that discerns details not otherwise imperceptible to the eye.
I don't understand. What?
Your Honor, because this was an observation that occurred with the drone, rather than, say, thermal imaging technology that could not be seen with the eye, it is distinguished from such technology.
Right, but if I'm walking down the street with my cell phone and I can use the camera and turn it to the wall of a house and look right through that wall and see what's going on, that's also observation. That would be permissible under your rule, correct?
No, Your Honor, because we are asking this court to consider the Stealth Eagle 2020 specifically and not necessarily future advancements to technology.
But the rule you're advocating for would apply to that situation. We have to consider not only the present application of your rule, but future applications as well, and how broad the rule is that you're advocating for. And under my understanding, you are advocating for a very broad rule that would encompass that situation. Yes or no?
No, Your Honor. Again, we are advocating only for the Stealth Eagle 2020, an item that was utilized by law enforcement in this case, rather than all
So
future.
if they change a feature or change the branding or just do it a little bit differently, we would have to do this all over again?
Not necessarily, Your Honor. You could make a distinction as a court. However, we are asking you only to consider the state of Olympus's capabilities here and what they utilized in this case to make such an observation.
Counselor, I don't think you understand our role. The rule that you're advocating for is much broader than just the facts of this case. We have to consider how it might affect all other situations that might come before us and how broad it might sweep, because officers on the ground will be reading this rule and then applying it to things that we have not considered. And so it's our job to consider how this rule might apply to different facts.
Correct, Your Honor. And although that is a consideration of this court has had to reconsider multiple things as technology advances. They had to reconsider in Kylo, the United States, with publicly available technology. And so at this time, drone use and the Stealth Eagle 2020 is in general public use. But future developments may require a different rule if this court observes that it is a violation of privacy. However, again, we cite Florida v. Riley to state that the officer's actions could be accomplished by a private citizen in the case at bar. Anyone could have purchased a similar drone and completed a similar observation. Because of these reasons, DeNolf Jr. being a temporary visitor to a recreational vehicle capable of movement and having no reasonable expectation of privacy from drone surveillance, we ask that you uphold.
Thank you, counsel. Good evening, Ms. Cooper.
Good evening, Your Honor. May I proceed?
You may.
Chief Justice, Associate Justices, and may it please the Court. My name is Olivia Cooper, and I rise to continue argumentation on behalf of Respondent for the Eighth Amendment issue in the case at bar. When a person is convicted of attempted murder, the public is not eager for that person to rejoin society, particularly when they have such a checkered history. DeNolf Jr.'s sentence follows the will of the people without violating the Eighth Amendment.
Counsel, this 50-year minimum is greater than most manslaughter statute penalties across the country where a person actually dies. How can this be just?
Your Honor, to that we can point to the solemn proportionality test, which states that we must consider 3 points when considering whether a punishment is proportional to the crime. The first point, we must consider the gravity of the offense and the harshness of the penalty. To this, we can point to the top of page 5 of the record, which states that had law enforcement not intervened, Jane Doe would have died. Mr. DeNolf's past offenses include an intent to kill at a disciplinary boot camp he was sentenced to, among other infractions. And the sobering realization of his offense in the case at bar, the punishment is not harsh and thus passes the first prong of the solemn test. The second prong of the solemn test asks us to consider sentences imposed for the same or worse crimes in the same jurisdiction. Here we can point to Proposition 417, found in Appendix 3 of the record, which was passed a few years ago by the people of Olympus.
Counsel, I would say to you that, was it 417, is that the number?
Yes, Your Honor.
Is facially unconstitutional in one of its sections as a violation of Graham, in that it allows for life without parole sentences in non-homicide offenses applied to juveniles. It was passed long after Graham was ordered by this court. The principle was well established in the law at the time, and the people of the state of Olympus passed it anyway, either knowing it was unconstitutional or ignorant that it was unconstitutional. So why should we look to that statute to find constitutional norms?
So, Your Honor, that particular statute, 417, actually does not give life without parole for the non-homicide offenses. It only provides for the 50 years, I believe, for the non-homicide offenses for second degree with the finding of incorrigibility. I believe that the life without parole is for actual murder as it stands.
It says in Section 3, non-adults who are convicted of first-degree murder or attempted murder can be sentenced to life in prison without parole if a judge concludes, etc., etc. That attempted murder, life without parole sentence for non-adults would violate Graham directly. So should we be looking at the rest of this statute to find the constitutional norms from this state?
Well, Your Honor, if this were first-degree attempted murder that we were considering in this, we would obviously need to find this unconstitutional. But as it stands, we are currently looking at the second-degree attempted murder, which within that statute does not provide for a mandatory sentencing, but instead a discretionary sentencing at the discretion of the lower courts, dependent upon the finding of incorrigibility before those 50 years are found. And so we can look to this and see that a juvenile in the same position, charged with the same crime as DeNolf Jr., would be given the same punishment as at the discretion of the lower courts. And so we can see that it passes point 2, comparing sentences imposed for the same or worse crimes in the same jurisdiction. We can also see that every single adult who was convicted of second-degree murder or first-degree attempted murder was given a harsher sentence than DeNolf Jr. We can then go to point 3 of the solemn test, which asks us to compare the same crime in different jurisdictions, where we see that 46 out of the 51 states allow juvenile life with parole sentences, which is the exact same sentence that was handed down to DeNolf Jr. So we can see that other jurisdictions are willing to impose the same punishment that DeNolf Jr. faces. And
well, I think you can't compare across states without comparing the time to parole eligibility. How does the 50-year mandatory, not 50-year mandatory in the law, but the 50 years actually imposed in this in this offense, in this case, compared to what other states allow?
So, Your Honor, in this case, while the 50 years is a more rare in practice, it is still implemented for the crime of second-degree attempted murder, as we can see in the case facts. But also, as Justice Thomas said in his opinion in the Graham case, that a punishment is rarely imposed demonstrates nothing more than a general consensus that it should be just that, rarely imposed. It is not proof that the punishment is one the nation abhors. Looking to this quote, we can see that just because it is a rarely imposed punishment just means that it's rarely imposed, which states that the crime might also be a rarely committed crime, but in such mitigating factors such as DeNolf Jr.'s, there is precedent for this. And to this we can also look to the finding of incorrigibility for DeNolf Jr. and his previous offenses. Now, these have increased in severity over time. He started off with shoplifting, but that escalated into a state felony charge of animal abuse. Now, the Miller, the
Roper, Graham, Miller, Montgomery, even to the Jones line of cases, talks a lot about adolescent development, and one of the things it says is that character is mutable. Youth change their character, they grow over time. And it said a lot of other things about adolescent development. And I would like for you to tell us why you think this case does or does not fit into the things those cases told us about youthful offending.
Yes, Your Honor. So it would be the finding of incorrigibility, and this goes back to the facts of Jones versus Mississippi regarding the finding of incorrigibility. And the finding of incorrigibility is up to the discretion of the lower courts in looking at things such as past offenses, which includes being sentenced to a disciplinary boot camp, and at that disciplinary boot camp, attempting by his own admission to kill 2 separate individuals.
Well, what I'm getting at is those cases tell us that youth are impulsive, that youth are present-oriented, and it said other things about how youth offend. And it strikes me that what we see here is a very impulsive youth, a very present-oriented youth who's not looking to his future. And I want you to talk about whether or not, is this just a manifestation of exactly the things those cases talked about is typical of youth, youthful offending at least?
Well, Your Honor, in the case of Miller versus Alabama, where these sentences were not upheld, we can also see that there was diminished mental capacity, but the facts of the record on page 1 stipulate that Mr. DeNolf was above average intelligence. And generally, when we are looking to the capacity for youth, we are still considering it, which is why he was not given a life sentence, and he was allowed the possibility of parole. He was simply given this 50-year sentence because of his previous offenses and because of this finding of incorrigibility. So even though my opposing counsel states that this is a virtual life sentence and points to page 6 of the record stating the 39-year stipulation, we can also see that 39 years that 39-year average is found with both juveniles as well as adults in their 50s or 60s who are in prison. And
Counselor, I wonder how our changing understanding of brain development impacts your position. In recent years, we've come to understand that an individual's brain is not completely developed until the mid-20s, maybe closer to 30, depending on the individual. How does that, or does that, affect your position at all?
Your Honor, it does, which is why, once again, in the cases of Graham and Solemn, you're not allowed to sentence a juvenile for a non-homicidal offense to life in prison, and he is still provided with the possibility of parole. But this troubling pattern of behavior with DeNolf.
But will he have a meaningful life when he gets out if he's, past retirement, has completely foregone opportunities to have a family of his own?
Assuming he is allowed out at age 65, he would still have another 12 or 13 years on average based on the life expectancy that we can find on page 6 of the record. But this 50 years follows because of a troubling pattern with DeNolf Jr.
But you also said assuming. What if he dies before he gets out? That's a very reasonable possibility, according to your friends on the other side.
Yes, Your Honor, and according to my friends on the other side, they were relying upon that 39-year statistic, which again does not take into account just juvenile life expectancy, but also takes into account the life expectancy of adults who are also in prison. So a much more reasonable expectation would be to look at the 77 to 78-year statistic that is listed on the same page for how long someone can be expected to live.
Assuming we agree with you that that this 54 years old life expectancy is not really controlling, should we be looking at, well, he won't be eligible for parole until he's 65 years old, and he will have missed so much of the things that go on in life. He would not have opportunities for children, grandchildren, etc. Is that something that we should be looking at within the expression meaningful opportunity for release?
Counsel, you have additional 30 seconds to answer.
Thank you, Your Honor. To that, Your Honor, I would reply that DeNolf Jr. has an unsettling pattern of behavior that we have seen. And this pattern of behavior, according to the peniological justification set forth in Graham versus in the Graham case, we can see that it's deterrence, retribution, incapacitation, and rehabilitation. The court has tried rehabilitation with Graham, or with DeNolf Jr., and will continue to try after those 50 years have elapsed. But we must try the other peniological justifications, such as deterrence and retribution for his actions. For these reasons, we ask that the ruling of the lower court be affirmed. Thank you.
Thank you very much. Thank you all. Wow.
We have rebuttal.
Oh.
We have rebuttal. Oh. Not done yet.
Thank you.
Permission to proceed, Your Honor?
Yes.
May it please the court, 2 points on rebuttal. First, where we just left off on the Eighth Amendment issue. Mr. Associate Justice, you asked opposing counsel how their reasoning, how their rule pairs with the string of cases from Roper to Graham to Miller to Montgomery to Jones that concluded that children are mutable, that they can change. And opposing counsel pointed to the one fact in this case that this court has declared categorically unconstitutional. The fact that the lower court found William DeNolf incorrigible. In Graham, the court said you cannot do that for juveniles convicted of non-homicide offenses. The reason for that is that children can change, as you pointed out, Mr. Associate Justice. The proclivity to risk, inability to assess consequences, and transient rashness are the marked characteristics of youth. And findings of incorrigibility, the idea that someone is permanently beyond rehabilitation, contradict those essential elements. Madam Associate Justice, you pointed to science and social science differentiating youth from adults. And that is, it flies in the face of a finding of incorrigibility and is inconsistent with this court's prior precedent.
Does that mean that we can't establish a bright line rule?
No, Your Honor, it means that we can establish a bright line rule. And the bright line rule is that findings of incorrigibility are categorically unconstitutional.
But in terms of, if we were to consider a bright line rule that a certain number of years for youth is unconstitutional, does that mean that for every offender, taking into account brain science, does that mean that we need to make an individual assessment for every offender and prohibits a bright line certain number of years rule?
No, Your Honor, the court found that the characteristics of youth apply to all juveniles as a class. And so Graham can be straightforwardly applied to William DeNolf as it can to any other individual who's a juvenile. Under the Fourth Amendment, you asked opposing counsel about whether or not a phone in the future could be used to see through walls, how it pairs with their rule. And I see that my time has expired. May I briefly conclude?
Please do.
They limited their rule by just simply the general public use standard in Kylo. However, that standard doesn't even apply to the Stealth Eagle 2020 because its technology, the 4 times optical zoom, the 10 times optical zoom, and the 4 times video quality is unique to that device alone. For that reason, we ask this court to find that the search was unconstitutional and reverse. Thank you.
Thank you.
Thank you. Yeah, now I can say wow. So, and I do say that it's wonderful. We're going to take a couple minutes in the back and then organize our thoughts like you guys were organized. We'll be right back with you.
So what we're going to do is, in the interest of getting the banquet started, because otherwise you're going to be a long line, we're going to ask that the competitors and their coaches stay for some short feedback, if you want to. If you want to, and we're going to suggest that everybody else do it after the table. So if you don't want that, that's fine, but side door, and then directly to the right, across the street. The bookstore and then the back of the book. You're not announcing the winner now.
Hi. Very well done.
Your ballots are all submitted?
Yes.
Yeah, submitted.
Do you guys have any questions for us before we give feedback?
Are you guys able to introduce yourselves and say what you do?
Sure. My name's Morgan Brungard. I work in the Louisiana Solicitor General's office. We handle mostly Fifth Circuit and United States Supreme Court cases.
Hi, my name is Fred Crafassi. I'm a judge here in East Baton Rouge Parish at the 19th Judicial District Court, where I hear mostly criminal trials.
I'm Richard Pittman. I'm the Director of Juvenile Defender Services for the state of Louisiana, and Miller, Montgomery, Graham, Roper are my stock and trades. Y'all may have noticed those questions were hard.
Yeah. But the job that my co-justices were doing, I had it easy because they were very well versed. You guys, however, handled it incredibly well. And just right now, all four of you, make sure you keep law school on your 5-year plan and go, please. Fantastic. I mean, I'm super impressed. Better.
How long have you guys been preparing?
May of last year's when the case comes out.
Okay.
We start reading through the cases.
6 months.
6-ish months. Okay.
Typical. It's good.
Good. In real practice, it would be a dream if you had 6 months to prepare an appeal. But very, very well done. This is what I do day in and day out, and you guys are better than 80, 90% of the people I see on a daily basis at this level. That's awesome. I think the thing that makes the best appellate advocate is your prep for the questions, being able to anticipate what they are and know how you want to answer them, not only substance-wise, but also verbiage, without becoming a robot. That is super hard, and you all did very well. You sounded very conversational. I knew that when I asked a question, it wasn't the first time you thought through it. That's awesome. And it also inspires confidence in your judge. That you can ask a question and the person is like, oh yeah, thought about that 5 years ago. That the answer that you're giving is right. The one thing I would say, and I see this in practice too, is to not fight the hypo. When somebody asks you, hey, your rule, like I think your rule also encompasses this other situation. If it's an outlandish situation that should never be constitutional, say no and why. My rule doesn't apply to that, and here's why. Otherwise, I thought everything was spot on. Your demeanor, you were not fidgety, but if you did use your hands, it worked. Your knowledge of the subject matter was very good. I even thought oftentimes appellate advocates are maybe not so familiar with all the facts of the cases, but just the holdings of the relevant cases. You guys navigated all of that very well. Were even able to understand or to explain a particular case's application of a previous case. Very, very well done.
I just respect you participating in this process and spending the time and the dedication, and because I truly believe, having gone through law school, and this prepares you better than any class you're going to have in law school, and it gives you an idea of what lawyers really do, and you guys are really masterful. I'm just amazed. So thanks. Mm-hmm.
I know y'all don't want to hear what y'all might have done wrong at this point, because there's nothing to apply it to. I would only say everyone was excellent. All four of you were absolutely excellent. I would only say this: if a judge invites you to make an argument that you weren't going to make, it's because that's what the judge is thinking is important. You shouldn't tell them it's not important. If they're inviting you to say, you didn't talk about this, but I'm thinking about that, you should go along with them and then make that argument, because they're trying to talk to their other judges and tell them that that's what's important, and you should follow them to that place. All right.
Any other questions?
I'm just curious. This is less to do with the round, but you said you worked in the Solicitor General's office in Louisiana, and then you defend juveniles.
I'm an administrator, but yeah, I'm the director of Juvenile Defender Services.
So did y'all have any experience with the Montgomery case?
Yes.
You did? I'd be really curious to hear just a little bit.
We've had sort of a series of cases, follow-on cases from Miller, Montgomery, and juveniles and what sentences are allowed and what are not. It's sort of an evolving issue in our state and elsewhere. So stay tuned.
I wasn't directly involved in the Montgomery case, but I was kind of indirectly involved, and I do know the person who argued it for Mr. Montgomery at the Supreme Court. I also know the person who argued Miller for the Supreme Court. That was Brian Stevenson of Alabama. You may be familiar with him. But no, I also know Mr. Montgomery's trial lawyers and the people who are working with him on parole. So.
Are we allowed to know where they're from at this point?
We're from Patrick Henry College.
It's a small liberal arts school in Northern Virginia. It's like an arts center.
Okay, lovely.
We're from the University of Texas at Dallas.
Okay.
Yay, Texas.
Fantastic.
Yay, Virginia. Awesome.
Well, I hope you enjoy your stay here.
Thank you so much.
Thank you for your efforts.
Of course.
It's been a pleasure.
Best of luck.
Absolutely.
Yay!